Good morning. I'm Dennis Aldana, President of the National Judicial College. On behalf of the National Judicial College and this event's financial supporter, Thomson Reuters, welcome to the 133rd Justice Jackson Lecture. Today's talk will actually consist of two pithy lectures by our esteemed guests, and more about that in a moment. I'm delighted to welcome three members of the UNR leadership this morning: President Mark Johnson, is the Provost here, Provost Kevin Carmen, and the Dean of the College of Liberal Arts, Deborah Monologue. In addition to our many guests this morning, we have with us here in the front rows the traditional audience for our Justice Jackson lectures, judges from all over the country who are participating in our twice-yearly general jurisdiction course for judges who are relatively new to the bench. Welcome, Your Honors. And again, if you think you might want to ask a question of our speaker, we'll be collecting the questions in writing. If you didn't get a slip on the way in, hold your hands and someone will come up and provide you a pen or a paper. Honoring the memory of Justice Jackson with this lecture series was suggested by his friend and Supreme Court colleague, Justice Tom Clark, one of the NJC's founders. In 1964, we began a tradition of presenting this lecture at the conclusion of general jurisdiction. This year, the judges have a few days of classes left. In case you're curious, you can read the names of some of our distinguished past Jackson lecturers on the back of your program. Robert Howitt Jackson was born on a farm in Pennsylvania in 1892 and never formally completed law school before becoming a Supreme Court justice. He learned under the old apprentice system as a law clerk. He speculated that he would probably be the last justice without formal legal training to join the Supreme Court. And he was right, at least so far. Justice Jackson came to government service the old-fashioned way, by having connections. His friend, Franklin Roosevelt, invited him to Washington to serve in the New Deal government. FDR appointed him Solicitor General in 1938 and Attorney General in 1940. On October 6, 1941, he took his seat on the Supreme Court. 4 years later, at the end of World War II, President Truman appointed Jackson to be America's chief prosecutor in the Nuremberg war crimes trials. He always regarded this as the single most important event in his life. After the war, Allied leaders met to decide what to do with the war criminals. The prevailing debate was over whether to hang or shoot them. In his opening address at Nuremberg, Jackson stated, "The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. That four great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason." Jackson's Supreme Court opinions similarly pulled no punches and are full of wisdom. In his dissent in Securities and Exchange Commission versus Chernery Corporation, here is how he characterized the majority view. The court's reasoning adds up to this: the commission must be sustained because of its accumulated experience in solving a problem with which it had never been confronted. I give up. Now I realize what Mark Twain meant when he said, "The more you explain it, the more I don't understand it." Jackson was a man of humanity and humor and was willing to poke fun at himself. Never much for the social circuit, he was heard once to observe, The best thing about these Washington parties is that you see, for a few minutes, a lot of people with whom a few minutes is enough. One of his last appearances on the court was on May 17, 1954. That was the day the Supreme Court handed down its unanimous opinion in Brown versus Board of Education case outlawing racial segregation in public schools in the United States. Justice Jackson had suffered a heart attack on March 30th of that year, and while still recovering, one and a half months later, he took his place on the bench on May 17 to emphasize the unanimity of the court on that issue. Later that year, in the morning of October 9, 1954, he died while on his way to the Supreme Court. It is appropriate that today's 133rd Jackson Lecture will be given by a man who has dedicated his life to justice and the rule of law. In 2017, Erwin Chemerinsky became the 13th Dean of Berkeley Law and Jesse H. Choper Distinguished Professor of Law. He was previously the founding Dean, Distinguished Professor of Law, and Raymond Pike Professor of First Amendment Law at the University of California, Irvine School of Law, with a joint appointment in political science. He teaches constitutional law, First Amendment law, federal courts, criminal procedure, and appellate litigation. If that weren't enough, he frequently argues appellate cases, including cases before the United States Supreme Court. He is the author of more than 200 law review articles and may have written another one in the time I've been reading this. He writes a weekly column for the Sacramento Bee, monthly columns for the ABA Journal and the Daily Journal, and frequent op-eds in the newspapers across the country. In 2017, he was named a Fellow of the American Academy of Arts and Sciences, and in January 2017, the National Jurist magazine named him the most influential person in legal education in the United States. He is the author of 10 books, to which will be the topics of his remarks here today: Free Speech on Campus, and Closing the Courthouse Doors, How Your Constitutional Rights Became Unenforceable. And then this morning, he just told us he has another book coming out this fall. So. Dean Chemerinsky truly exemplifies the qualities held in esteem by Justice Jackson. We are so privileged to have him with us, and I know you will enjoy and learn a great deal from his remarks. Dean Chemerinsky.
Thank you so much for that incredibly kind introduction and warm welcome. It's truly my honor and great pleasure to be with you. It's an enormous honor to be the 133rd Jackson Lecturer. I was looking at the back of the program and seeing the names of some who preceded me. I truly feel like the answer to the Sesame Street question, which of these doesn't belong? When I'm invited to speak, I always ask, what would you most like me to talk about? They said, we'd like you to talk about the 2 books that were published last year. One is titled Free Speech on Campus, and the other is titled Closing the Courthouse Door, How Your Constitutional Rights Became Unenforceable. I said, the problem is those books don't have anything to do with one another. How do you want me to speak about both? And President O'Donnell very kindly explained and said, some of the audience will be college students, and they'd really like you to talk about free speech on campus. And some of the audience is going to be judges, and they'd really like you to talk about closing the courthouse door. So how about spending 20 minutes on each? I always try to do what I'm asked, get less trouble that way, and maybe you can think of it as 2 speeches for the price of 1. As to the former, I've often thought that each generation is the first to think that it's the one to really discover sex. Likewise, I've often thought that each generation is the first to believe that it's really discovered issues of free speech on campus. But the reality is, campus protests have existed as long as there have been colleges and universities. Yet I think things have changed in recent years. Our mental image of free speech on campus was so shaped by what went on at Berkeley with the free speech movement in the mid-1960s. It was Berkeley students demonstrating, claiming the right to engage in speech on campus that was unrelated to college or university administration. Now, though, so often issues of free speech on campus about outsiders want to use the college university as their platform. It involves people like Milo Yiannopoulos, Richard Spencer, Ann Coulter. Often, it's outside groups that try to keep them from speaking. When Milo Yiannopoulos was going to speak on the Berkeley campus in early February 2017, it was the radical group Antifa that demonstrated to keep him from being there. At the same time, I have the sense that attitudes about free speech among college students have shifted over time. There was recently a survey by the Pew Research Institute that said that 40% of undergraduates surveyed favor allowing college universities to restrict offensive or racist speech. Some of this is the most laudable of motives. This is the first generation to be taught from a young age that bullying is wrong, and they've internalized the message. Some of it, I fear, is a lack of understanding of the history of free speech. I'm constantly surprised by how much current college students want to put trust in college administrators to decide what speech to allow and what speech to prohibit. I've increasingly come to realize that talking about free speech on campus, it's important to draw a distinction between a description of what the current law is and a discussion of what the law should be. I saw this on my own campus last September. The college Republicans and Patriot Group had invited a number of very controversial speakers to come to UC Berkeley. The initial speaker was to be Ben Shapiro, and then in a promised Free Speech Week, it was to be Milo Yiannopoulos, Steve Bannon, and Ann Coulter. In anticipation of this, the Chancellor, Carol Chris, called together a faculty panel to discuss the issue of free speech on campus. A large auditorium was packed. Every space in the stairs in front was filled with people sitting. One of the faculty members, my colleague John Powell, said to the audience that the largest problem in American society is white supremacy, and that the Chancellor should exclude any racist speakers, no matter what the First Amendment requires or what the courts say. There was resounding applause from the audience. Then, when the question-answer period came, a student spoke very eloquently, very powerfully, of how she feels threatened when there are hateful speakers on campus. She said she urged the Chancellor to stand up for the students and staff and faculty, to exclude these speakers, even if it meant defying the courts. There was resounding applause. Towards the end of the panel discussion, I spoke up as a faculty member been invited to participate. I said, let's be clear. If the Chancellor were to exclude these speakers, she would get sued and she would lose. When Auburn University excluded the white supremacist Richard Spencer, he and his supporters sued, and they won. The Chancellor would have to pay the attorney's fees for the excluded speakers. She might be personally liable for money damages. The excluded speakers would portray themselves as victims and martyrs, and nothing would be gained. The speakers would get to appear on the Berkeley campus anyway. No one applauded when I said that. So let me, in my few minutes now, summarize for you what I think are the most important principles with regard to free speech on campus, and also identify some of the cutting-edge issues. I can summarize this in 3 points. First, all ideas and views can be expressed on a college campus. Period. Now, of course, I'm speaking here of public universities like the University of Reno or University of California, Berkeley. The Constitution and the First Amendment apply only to government institutions. Private college universities don't have to comply with the First Amendment. But there are other sources of law that might apply free speech principles even to private college universities. In California, there's a statute called the Leonard Law that says that private college universities cannot punish speech that the First Amendment keeps public college universities able to punish. Also, most college universities have faculty and student handbooks that express a commitment to free speech, Many courts have said that these student handbooks and faculty handbooks constitute a contract with those groups, respectively. And beyond that, I would hope that college universities, public or private, be deeply committed to academic freedom, freedom of speech. The ability to express any view and idea is core to academic freedom. The ability to express any idea or view also includes the ability to express offensive, even deeply offensive messages. An illustration of this from the Supreme Court was a case earlier this decade, Snyder versus Phelps. It involved a small church out of Topeka, Kansas, the Westboro Baptist Church. They make it a practice of going to funerals of those who died in military service and using them as the place for expressing a very vile, anti-gay, anti-lesbian message. Matthew Snyder was a Marine who died in military service in Iraq. The members of the Westboro Baptist Church traveled to his funeral in Maryland. Before the funeral service began, they asked a police officer where they could lawfully stand. The officer pointed to a space about 1,000 feet away from the funeral to be conducted. Before the service, they chanted and sang. During the service, they held up signs. That night, Matthew's father, Albert Snyder, was watching the news. He was able to read what was on the signs. He was deeply offended. He sued for intentional infliction of emotional distress and invasion of privacy. A jury awarded him $10 million. But the Supreme Court 8-1 said that the jury's verdict violated the First Amendment. Chief Justice Roberts wrote for the court was clear. The government cannot create liability or punish speech or deny benefits for speech because of the idea or view expressed. Second principle, freedom of speech is not absolute. In fact, there are categories of unprotected speech. I'm sure you're all familiar with the words of the late Justice Oliver Wendell Holmes that there's no right to falsely shout fire in a crowded theater. We can all think of examples of speech that the government can prohibit and punish. At least since 1942 in Chemerinsky versus New Hampshire, the Supreme Court has said it would identify categories of unprotected speech. Child pornography is a category of unprotected speech. The government can not only prohibit sale and distribution of child pornography, but even forbid private possession in the home. False and deceptive advertising is a category of unprotected speech. There are three categories of unprotected speech that are relevant for the discussion of free speech on campus. One of these is incitement of illegal activity. The Supreme Court long has said there's no First Amendment protection for speech that incites others to violate the law. But here is with regard to all of these categories, it's important to separate the legal test for when the speech can be punished from the more colloquial use of the word. The legal test for when speech can be punished incitement comes from Brandenburg versus Ohio in 1969. It says that in order to punish speech as incitement, it must be advocacy where there is a substantial likelihood of imminent illegal activity and where the speech is directed at causing imminent illegal activity. So, for example, imagine on this campus, there's a speaker talking to an angry crowd, and the speaker exhorts the crowd to go commit acts of violence, to commit acts of vandalism, to light buildings on fire. I think in that context, the speaker could be punished for incitement. But imagine there's a controversial speaker. Make it Milo Yiannopoulos or Richard Spencer. And an angry crowd comes against that speaker. The speaker can't be punished for that. Even if it was a predictable reaction. Under the First Amendment, the reaction of the audience isn't a basis for suppressing the speaker. A second category of unprotected speech are what the Supreme Court has called true threats. That phrase comes from a Supreme Court case in the mid-1960s, United States versus Watts. There, the Supreme Court upheld a federal law that makes it a federal crime to make a threat against the President of the United States. The Supreme Court said, though, it's important to distinguish between, quote, a true threat and mere hyperbole. In And so imagine the context of a campus. A student is walking along, and an angry group surrounds that student. The angry group yells things that causes the student to fear for his or her physical safety. Even if no blows are struck, the speakers can be punished. The Supreme Court has been clear. There's no First Amendment right to cause a person to reasonably fear imminent harm to his or her physical safety. A third category of unprotected speech, relevant for college universities, is harassment. The law is clear in the employment context that speech that constitutes harassment can be the basis for liability. Think of the easiest example. An employer who says to an employee, "Sleep with me or you're fired," surely would have no defense based on freedom of speech if sued for sexual harassment. Likewise, the Supreme Court has said that speech that creates a hostile working environment can be the basis for liability. There's very little law yet in terms of when speech on campus crosses the line to harassment. But I think the law that exists with regard to the workplace is instructive. The Supreme Court has said that generally the speech has to be directed at a person, or it has to be sufficiently pervasive to materially interfere with employment opportunities on the basis of race, sex, religion, or sexual orientation. Likewise, I believe the speech is directed at somebody, or if it's so pervasive, to materially interfere with educational opportunities based on race, sex, or religion, or sexual orientation, it can be a basis for punishment. Compare two examples. There was an incident at the University of California, San Diego, where somebody put in the library what looked to be a noose. There was an incident at Duke University where someone draped over a tree branch what appeared to be a noose. A vile form of hate speech. But in that context, I don't think it would constitute a true threat, and by itself it wouldn't be harassment. But imagine that somebody tagged appeared to be a noose on a door in a dormitory room occupied by an African American student. I think that unquestioned harassment, and whoever did it could be punished. So I've quickly covered the categories of unprotected speech that seem most important for college universities: incitement of illegal activity, true threats, harassment. You'll notice what I didn't list as a category of unprotected speech: hate speech. The Supreme Court has been clear that hate speech is speech protected by the First Amendment. So many times I've been asked by reporters or people in the audience, what's the line between free speech and hate speech? And the answer is, free speech includes hate speech, according to the Supreme Court. You might remember the late 1970s, the Nazi Party wanted to march in Skokie, Illinois. Skokie is just north of Chicago. It was then a predominantly Jewish suburb with a large number of Holocaust survivors. Every court to rule, including the Supreme Court, held that the Nazi Party had the right to demonstrate in Skokie. Or another example, Supreme Court case from 1992, RAV versus City of St. Paul. St. Paul, Minnesota adopted an ordinance prohibiting painting a swastika or burning a cross in a manner likely to anger, alarm, or cause resentment. The Supreme Court unanimously declared that ordinance unconstitutional, making clear that hate speech is protected by the First Amendment. In the early 1990s, over 350 college universities adopted so-called hate speech codes. Every one to be considered by a court, without exception, was declared unconstitutional. Why? After all, virtually every European country has a law that prohibits hate speech. Some of it, I think, is the inability to define what's hate speech in a manner that's not unduly vague or overbroad. Under the First Amendment, any law, any public university regulation of speech has to be clear about what's prohibited and what's permitted. Most college universities in the United States tried to copy European laws. The University of Michigan, for example, after a series of ugly incidents on campus, adopted a speech code. It prohibited speech that, quote, stigmatized or demeaned on the basis of race, sex, religion, sex orientation. But what does it mean to stigmatize or demean? A sociobiology graduate student brought a lawsuit challenging this, saying his research was about whether inherent behavioral differences between men and women. He worried that the outcomes of his findings might be seen to stigmatize or demean on the basis of sex. Also, the experience under these hate speech laws should cause us pause before endorsing them. So often they're used against the very groups they're meant to protect. At the University of Michigan, between the time they adopted their hate speech code and when a federal court declared it unconstitutional as vague, every enforcement action under it was brought against African American and Latino students. When England adopted its first hate speech law, the initial prosecution under it was against a Zionist group, with the prosecutor claiming Zionism as a form of racism. You'll be surprised if I tell you who's been most frequently prosecuted under France's hate speech law. The actress Brigitte Bardot. She's an animal rights activist, and she's very much against the ritual use of animals as part of religious observances. And several times she's been prosecuted in law for what she said. But most of all, I think that hate speech is protected in the United States because it expresses an idea, albeit a vile one. Remember the First Amendment, all ideas and views can be expressed. Third and final point. Colleges and universities can use time, place, and manner restrictions so long as they leave open, adequate, and important places for communication. Even when there is a right to use government property for speech, the government still has the ability to regulate when, where, how it occurs, so long as it leaves adequate alternative places for communication. In the context of college and universities, they can use time, place, and manner restrictions so as to prevent disruption of campus activities and so as to protect safety. A college university can prevent demonstrations, protests in or near classroom buildings while classes are in session. A college or university can use time, place, manner restrictions to protect the safety of students, staff, and faculty. After all, college universities have a legal as well as a moral obligation to protect the safety of the students, staff, and faculty. Last summer, when I arrived at Berkeley, the Chancellor, Carol Christ, very kindly asked my advisor how to handle the coming free speech issues. I said, have the most controversial speakers speak in an auditorium like this one, not in the middle of the campus. I said, if it's an auditorium, you can require tickets of identification. If necessary, you can have metal detectors. Police can secure the perimeter. If it's in the middle of campus in Sproul Plaza, that's impossible. One of the hard, unresolved issues is how much does a college or university have to spend for safety to ensure free speech? Where is the point at which a college or university can say, we just can't afford the cost of security, and therefore we're going to prevent the speaker? The University of California, Berkeley spent $3.9 million for security for the events that I alluded to in just the month of September 2017. What if it wasn't Free Speech Week there? What if it was Free Speech Semester? What if the cost wasn't $4 million, but $50 million? Where is the point at which a college or university says, we just can't afford it? There is no law on point here. When Chancellor Christ asked me this question, I explained that. I said, if I were your lawyer, and I'm not, you have campus counsel, I would tell you to think of two things. First, what's your stomach for litigation? If you exclude a speaker because you don't want to bear the cost, you'll get sued. Sure, what will happen in the court, because there's no law on point. And if you lose, the campus has to pay the attorney's fees. And what do you want your message to be at this point in time? She decided she wanted the message to be that Berkeley is a free speech campus. She allowed the speakers, the campus absorbed the costs, but it doesn't resolve the underlying issue. So I've summarized for you what I think are the key principles with regard to free speech on campus. At the same time, I believe that college and universities have the obligation to do everything they can to create an inclusive learning environment for students, so long as it doesn't involve restricting speech based on ideas or views. I realize that this doesn't persuade those who disagree with me. This doesn't convince those who want to see college university more to restrict hateful expression. But to those who have this view, I try to explain that the only way that our free speech can be protected tomorrow is to safeguard the speech we don't like today. We don't need the First Amendment to protect the speech we like. We'd let that go on anyway. We need principles of freedom of speech to safeguard the speech we detest. Ultimately, the First Amendment is based on a faith. The faith is we're better off letting all ideas and views be expressed rather than letting the government or campus officials pick and choose the messages we can hear and those that they won't allow. I share that faith, at least most of the time. Served in the Marines for a long time. She was stationed in Washington, D.C. She was allowed to live off base in an apartment. One morning at 5 a.m., several of her fellow Marines came to her apartment. They let her in, and they gang raped her. She immediately filed a complaint in the military describing what had occurred to her. She then suffered extreme harassment, was ostracized, so much so that she attempted suicide and left the military. Janet Galla served in the Navy for a long period of time. She was on a ship. She was in a relatively small area. A man came in. He raped her. She also filed a complaint, and she too discovered that she suffered harassment and ostracism, that she was told she should no longer be on ships, and she had to leave the Navy. She and about a dozen other women suffered rape, egregious sexual harassment, brought a lawsuit against the top officials in the military, saying that they created an environment that led to such sexual assaults and sexual harassment, and refused to provide protection for women who were victims. The United States Court of Appeals for the District of Columbia Circuit ordered the suits by Clay and Galla and the other women dismissed. The D.C. Circuit said that this was an easy case, that those who serve in the military cannot bring civil suits under any circumstances for the injuries they incur in service. Now, this wasn't about service people who were injured in war. This is about women who were raped, who sued the military for having taken steps that led, they believed, to this occurring, steps that led to them being harassed and ostracized. But the United States Court of Appeals for the District of Columbia Circuit said there would be no suit. The United States Supreme Court denied review. I mention that because this suit is typical of an ever-increasing number of situations where the Supreme Court and other courts are closing the courthouse doors. Our rights are meaningless unless there's a forum to go to that will hear our claims and enforce our liberties. I think that Marbury versus Madison got it exactly right in 1803, when Chief Justice John Marshall said, "The Constitution exists to limit the government. The limits are meaningless if there aren't courts to enforce them." That's why Chief Justice Marshall so powerfully declared in Marbury that it's the province and duty of the judicial department to say what the law is. But what I argue in my book, Closing the Courthouse Door, is that in so many areas, the Supreme Court and other courts are keeping those whose rights have been violated from ever having their day in court. This seems to me particularly insidious because it's largely invisible to the public. If the Supreme Court were to hold that the government can give unlimited amounts of money to parochial schools, that would be the headline of every newspaper in the country. But if the Supreme Court holds no one has standing to challenge the government giving aid to parochial schools, the result is the same, but it won't be headlines of the newspaper. Newspapers don't cover the doctrine of standing to sue in federal court. I go through many different areas of law in the book. Let me, in the few minutes I have, pick three, and they're illustrative of how the courthouse doors have been closed. is the Supreme Court has made it so difficult to sue government officials, federal, state, or local, who violate the Constitution. My example of Ariana Clay and Janet Gallup fits with this trend. It's often impossible to sue the government entity, even when it violates people's rights. The United States government and state governments have sovereign immunity. There are only limited exceptions when they can be sued. Local governments can be held liable only if their own policy violates the Constitution. So often it's suing the government official or not being able to sue at all. And yet, in case after case, in doctrinal area after doctrinal area, the court has made it impossible to sue government officials. When it comes to suing federal officials, there's no statute that explicitly authorizes litigation for constitutional violations. There was a Supreme Court case in 1971, Bivens versus 6 unknown named agents of Federal Bureau of Narcotics, that said that if a federal officer violates the Constitution, he or she can be sued for money damages. The case involved Wesley Bivens. He was subjected to a very degrading, humiliating search by agents of the Federal Bureau of Narcotics, and he sued them with the Fourth Amendment. And the Supreme Court, in an opinion by Justice Brennan, said that enforcing the Constitution requires a remedy. Damages are available. Justice John Marshall Harlan, in a concurring opinion, said, for people in Bivens' shoes, it's damages or nothing. But since 1980, 38 years now, every Supreme Court case to deal with Bivens, without exception, has narrowed its availability. Very little is left. The most recent case was just in the spring of 2017, a case called Ziegler versus Abbasi. What this involves a group of Muslim men who were detained in New York after 9/11. They claimed that they were detained solely on the basis of their race and ethnicity. They said they were subjected to extreme interrogation, both mental and physical. They talked about noise being broadcast at loud decibels 24 hours a day. They talked about being slammed against walls, sometimes so hard that bones were broken. They sued the individuals who were responsible for this. The Supreme Court, though, ruled in an opinion by Justice Kennedy that these victims could not sue for money damages. Justice Kennedy said that Bivens suits should be allowed only under very limited circumstances. The court said it would permit it only where the court has previously recognized allowing Bivens suits. It shouldn't be expanded. And even then, the court said it should never be allowed when it's a challenge to a government policy. It should never be allowed when national security issues are at stake. But as Justice Breyer pointed out in his dissent, for the men who suffered this harm, there is no other recourse. If they can't sue their captors for money damages, they're not allowed to sue the United States. There's no one that they're able to sue. And whether it's federal officers, state officers, or local officers who are sued for money damages, they always have what's called an immunity defense. Some government officers have absolute immunity. Prosecutors can't be sued for money damages for their prosecutorial acts, even if a prosecutor knowingly uses perjured testimony that leads to conviction of an innocent person. The prosecutor can't be sued for money damages. A police officer can't be sued for money damages for testimony given in court. In Briscoe versus LaHoo in 1983, the court said even if the police officer knowingly lies under oath and it leads to the conviction of an innocent person, the police officer has absolute immunity. The President of the United States can't be sued for money damages for anything done in office, no matter how great the injury inflicted, no matter unconstitutional behavior. And even for the officers who don't get absolute immunity, they still get what's called qualified immunity, and they can be held liable only if they violate a constitutional right that every reasonable officer would know. That's a right established beyond dispute. And in case after case, the Supreme Court has held that victims of police abuse, victims of excessive force, cannot recover. There was a Supreme Court case just this month, a case called Casello versus Hughes. Police came to a scene where a woman who was obviously suffering mental illness was hacking away at a tree with a knife. The police thought that the knife might be used against somebody else, and they shot and wounded the woman. Now, the woman hadn't pointed her knife at anybody else. There was plenty of time if there was a threat to take action. The United States Court of Appeals for the Ninth Circuit said, let a jury decide whether this is excessive force. The Supreme Court, without briefing or argument, summarily reversed and said that the police officers couldn't be held liable. They had qualified immunity. If we can't sue the government, and we can't sue government officials, then there's nothing to deter wrongdoing. There's no way to compensate those who are victims. Let me mention a second example of closing the courthouse door, and that's one that affects all of us. And this involves arbitration clauses. Arbitration clauses keeping us from going to court, requiring us to go to arbitration, are increasingly ubiquitous. The Supreme Court consistently has said they should be enforced even though they closed the courthouse doors. There was a Supreme Court case several years ago, AT&T Mobility versus Concepcion. The Concepcions, a married couple, went to an AT&T store. They saw signs that they would get free cell phones if they signed up for the AT&T service. They, like all of us, signed the agreement for their service. They, like most of us, didn't read the agreement they were signing. They were surprised when at the end of the first month they got a bill that included $32.80 in sales tax. They thought that AT&T should pay that since it promised free cell phones. They decided to bring a suit against AT&T for fraud. It's going to be a class action suit. The court said they could go forward with their fraud suit, but AT&T then brought its own action and said, no, there was a clause in the agreement that said if there was any dispute, it had to go to arbitration, and it had to be individual arbitration. It couldn't be class-wide arbitration. The Supreme Court ruled 5-4 that the arbitration clause had to be enforced. The Concepcions could go to court. Earlier in 2001, there was the case Circuit City versus Adams. St. Clair Adams applied for a job at Circuit City. When I teach this case, now I have to explain to my students what Circuit City used to be. But I also know when I teach Cherry versus Ohio in the fall, I need to explain to my students what a phone booth used to be. He filled out the application for the job. He didn't notice on the back in very tiny print it said that if any dispute in Circuit City, he had to go to arbitration. He couldn't go to court. After working for Circuit City a couple of years, felt he was a victim of race and sex discrimination. He filed a suit in California State Court. But the United States Supreme Court ruled this to 5-4 that the arbitration clause had to be enforced. These are just two of many cases where the Supreme Court has held that arbitration clauses have to be enforced. People don't get to sue in court. As I said, arbitration clauses are so common now. They're in medical contracts, consumer contracts, employment contracts. Not long ago, I went to see a new eye doctor for the first time, and the receptionist gave me a big stack of papers to fill out. In the middle was a form I was asked to sign that if any dispute with the doctor arising out of the treatment, I couldn't sue in court, I'd have to go to arbitration. I asked the receptionist if the doctor would still see me if I didn't sign the form. She said she didn't know. Nobody ever asked her that question before. I now know many doctors who won't treat patients unless they sign arbitration agreements. Around the same time, I bought a new Dell computer. As you know, in order to use a computer or an iPad for the first time, you have to click that you've read the terms and agree to them. For the iPod, the terms are 56 single-space pages long. I usually just click, I agree, and use the machine. But here I decided to read the terms. And sure enough, there's a clause that if any dispute with Dell arising from the computer, I couldn't sue in court, I'd have to go to arbitration. I wrote Dell a letter saying I didn't agree to that clause, and by opening the envelope of my letter they agreed, I could sue them in court if they had a dispute. Dell didn't write back, and the computer no longer works. Let me give a third and final example, and that's how the court is interpreting statutes to keep injured people from being able to go before the judiciary. And this, too, affects all of us because it concerns prescription drugs. And there are a couple of Supreme Court cases just this decade that are enormously troubling. One is a case called Cleaver versus Mensing. It involves a drug that's prescribed to speed up digestion. It's a drug called Reglan. It's now known that prolonged use causes serious side effects. 29% of prolonged users will suffer really horrific, irreversible neurological side effects. It's now required to have the black box warning, the strongest warning. 2 women took the drug for a long time and suffered the side effects, sued in court. Each one in their state court. However, the United States Supreme Court 5-4 reversed. Justice Thomas wrote for the court, joined by Chief Justice Roberts, as well as Justice Scalia, Kennedy, and Alito. Justice Thomas said, the Hatch-Waxman amendments to the Food and Drug Act say that a prescription drug can be sold if it's the same as the generic drug. The generic drug can be sold the same as the brand name drug. These women took the generic form of the drug. The Hatch-Waxman Act says that the generic drug can be sold if it's chemically the same as the brand name drug and it's the same warning label as the brand name drug. Therefore, the court said the generic drug company couldn't change the warning label, so it can't be held liable in any way. Justice Thomas, the end of the said, now if the women had taken the brand name drug, they could have sued and recovered for failure to warn. But that's for Congress to fix, not for the court. Justice Sotomayor wrote a vehement dissent. This makes no sense. The law's clear. If they took the brand name drug, they could win. Because they took the generic drug, they were left without any remedy. The court followed this up a couple years later in a case called Mutual Pharmaceuticals versus Bartlett. A woman in New Hampshire was given a prescription for the pain reliever Soldenac. Her prescription was filled with the generic form of the drug. She took it as prescribed, and she suffered horrific, though known, side effect. 2/3 of the skin on her body burned, blistered, and decayed. She spent months in a medically induced coma. She's permanently blind and disfigured. She sued the maker of the generic drug. She won in the New Hampshire courts. But the Supreme Court held 5-4 that she couldn't recover. Here, Justice Alito wrote to the court. Justice Alito said, the Hatch-Waxman Act says a generic drug can be sold if it's the same as the brand name drug. It has the same chemical composition and the same warning label. He said, we said in Cleaver versus Mensing that a maker of a generic drug can't be held liable for failure to warn, nor can it be held liable on a design defect theory. According to the FDA, over 80% of all prescriptions are filled with generic drugs. If there's a generic that's the same as the brand name drug, for 90% of the time, the prescription is filled with a generic drug. But if any of you or a loved one takes a generic drug and is injured, they can't sue. They can't sue for failure to warn. They can't sue for a design defect. They can't sue in federal court. They can't sue in state court. The Supreme Court has simply closed the courthouse doors. We were all taught, maybe in civics, that anybody who's injured should have his or her day in court. What I argue in my book is that sadly, that's increasingly no longer true. Thank you.
Thank you, Dean. I'm going to take a few questions right now from the audience and collect them. First question I have is, do you believe there is a public policy solution to fake news that does not impede free speech?
I don't think there is a legal solution to fake news. I think there is a public policy solution. Let me be clear that the First Amendment sometimes allows for punishment of false speech, and sometimes doesn't allow for punishment of false speech. Perjury, for example, is false speech that can be punished. As I mentioned earlier, false and deceptive advertising is false speech that can be punished. But the Supreme Court has also said that there are times when false speech is protected by the First Amendment. New York Times versus Sullivan in 1964 said that we have to provide protection for false speech in order for there being the breathing space that freedom of expression needs. There was a Supreme Court case a few years ago, United States versus Alvarez. It involved the Federal Stolen Valor Act. federal law made it a federal crime for a person to falsely claim to have received a military honor. Now, the man, Javier Alvarez, who claimed falsely received the Medal of Honor. The Supreme Court 6-3 overturned his conviction, saying that false speech is protected by the First Amendment. I do not believe there's a way under the First Amendment to prohibit and punish false political speech. But I think there's a public policy solution. More speech. Justice Oliver Wendell Holmes said, the best remedy for the speech we don't like is more speech. The best solution for false speech is more speech. I'm not naive. I don't believe it will always work. If somebody says something false about me that's terribly injurious to their reputation, more speech isn't going to eliminate the taint, but I don't think we can have the government, the courts, and the business deciding what's true and false in the political arena. I don't think the court would allow that.
Next question is, there seems to be a belief that many college students are devaluing First Amendment rights, and what can we do to rekindle public respect for the absolute value of free speech?
I always want to be careful of overgeneralizing. The last 2 years, I taught an undergraduate class titled Free Speech on Campus at UC Irvine. But I do think from that experience, from opinion polls, that more among college students today than we've seen previously would favor restriction of offensive or hateful speech. I think that part of it is the lack of understanding about the history of free speech. I think my students who are so inclined don't realize how much free speech has been integral for expansion of civil rights. That women getting the right to vote in the 19th Amendment was a result of the demonstrations of the suffrage movement. The changes with regard to civil rights in our society wouldn't have occurred when the civil rights demonstrators and protests of the early 1960s. This is, I said, a generation that's been taught from a young age that bullying is wrong, and I admire that. But I also realize that the civil rights protests of the 1960s, the anti-Vietnam War protests of the 1970s that I participated in when I was in college, are as long ago for this generation of college students as World War I was for me. And so I do think that there's a need to educate people. I'll say more generally, I think we as a society do a terrible job of civic education about free speech and everything else. I think if we want our democracy to survive in the long term, we've got to find a way to do that much better.
Here's a specific question. What do you think of calls to fire Professor Rhonda Girard for her tweets about former First Lady Barbara Bush?
This is the professor at Fresno State University. I would draw a distinction between speech of a professor in the professional realm versus speech of the professor in a non-professional capacity. When it comes to the professional realm, of course we evaluate professors based on their speech. When we consider a professor for tenure promotion, we're looking at the content of what's written. When it comes to teaching, if a professor in my law school is assigned to teach contract law, and comes in every day and talks about baseball and NCAA playoffs, I can say, no, you're not doing your job. Likewise, in grading student papers, of course, evaluating based on the content of what's written. But when it comes to the non-professional realm, what we say, do over the weekend, what we write on Twitter, I don't think a campus can punish a professor for that. So I think it would violate the First Amendment to punish that professor for what you wrote. And in fact, there's even a Supreme Court case close to that point. It's a case called Rankin versus McPherson that involved a government employee. It was after President Ronald Reagan was shot, and the government employee said, I hope they kill him the next time. And she got fired for that. And she sued and she won. The court saying it's offensive, but it's speech that's protected by the First Amendment.
What role do state courts need to play to keep the courthouse doors open? Can state courts provide a firewall against the trend you described?
It's a great question. As federal courts become increasingly inhospitable, it's going to be the responsibility of states and state courts to protect rights. In 1977, William Brennan wrote a very famous article in the Harvard Law Review about the importance of using state constitutions to expand liberties and to enhance equality. I think this goes to keeping the courthouse doors open as well. I'll give a single example. Many states have in their state constitutions right to redress clauses. In these can be used, I think, to create a right of access to the court where there's nothing comparable in the United States Constitution.
This is about the newest member of the Supreme Court. What has been the effect of Justice Gorsuch in the court?
From 1971 until February 13th, 2016, there were always at least 5 and sometimes as many as 8 justices appointed by Republican presidents. When Justice Scalia died, there were 4 justices appointed by Republican presidents and 4 appointed by Democratic presidents. Major ideological shifts on the Supreme Court are rare. The Supreme Court became quite conservative in the 1880s and stayed that way until 1937. There was a Democratic majority on the Supreme Court in the late 1930s until 1971. If Hillary Clinton had won and replaced Justice Scalia, it would create a majority of justices appointed by Democratic presidents for the first time since 1971. Neil Gorsuch, however, replacing Antonin Scalia, means that the court's ideological balance stays the same as before Justice Scalia's death. It means we have 5 justices appointed by Republican presidents and 4 by Democratic presidents. Or to put it another way, there are 4 quite conservative justices on the court: Roberts, Thomas, Alito, and Gorsuch. 1 moderate conservative. He votes with the conservatives more often than the liberals, but is the swing justice, Justice Kennedy. And 4 liberal justices, Justice Ginsburg, Breyer, Sotomayor, and Kagan. So Justice Gorsuch replacing Justice Scalia keeps the ideological balance the same. But 2 thoughts about this. One is, Neil Gorsuch is going to be on the Supreme Court for a very long time. He was 49 years old when he was sworn in on April 6th, 2017. If he remains on the court till he's 90 years old, the age was just John Paul Stevens retired, Neil Gorsuch will be Supreme Court Justice for 41 years. As I said to my students, that would mean to be a justice to the year 2058. They can go a long part of their careers and their lives to be a justice, Neil Gorsuch. The other, of course, is the question of will President Trump get to replace another justice between now and January 20th, 2021. Did you know that since 1960, 78 years old is the average age of Supreme Court justice left the bench? As we're together today, there are 3 justices over that age. Ruth Bader Ginsburg turned 85 on March 15th. Anthony Kennedy will turn 82 on July 23rd. Stephen Breyer will turn 80 on August 15th. If any one of these 3 justices are replaced by President Trump, that will create a major ideological shift. It will create the most conservative court we've had since the mid-1930s.
Dean, this morning during breakfast, you had mentioned that your views on campaign speeches by judges has evolved. Could you share with the judges how that has evolved in your current position?
Sure. I was asked at breakfast to identify an area where I've changed my mind, and there are many of them, but one of them is that I used to take the position that in a state where there's election of judges, in whatever form, judges should have the same free speech rights as anybody else who's running for office. That if a state chooses to make judges into politicians, they should be able to speak and raise money like anybody else who's running for office. I've come to think I made a mistake in those articles. I don't believe that anymore. I think that judges are different from other politicians, even if state law turns them into politicians by them run for election or potential election. So I think the Supreme Court got it right in William Julie versus Florida State Bar in saying that a state consistent with the First Amendment can prohibit those running for judicial office from directly raising money. I think that the Supreme Court got it wrong in Republican Party Minnesota versus White in saying that restrictions on speech in the Judicial Code of Ethics are unconstitutional. I think that the First Amendment should be able to treat those running for judicial office different than those who are running for other offices.
Last question. What do you see as your legacy beyond your accomplishments as deans of 2 prestigious law schools?
I hope I'm going to get to do this for a while, so I'm not ready to start thinking about legacy. I think I'd answer that in the same way as anybody who's in this room who's a parent. My most important legacy is my 4 children and my 2 grandchildren.
such enlightening remarks and for challenging us to really think about these two important issues. On behalf of the National Judicial College, as a token of our appreciation, we want to present you a crystal gavel. I know that you don't hang these on your wall, but this will be suitable for your desk. We also have a book recently published, newly discovered manuscript by Supreme Court Justice Robert Jackson. I don't know if you have a copy of it.
I don't have it. Thank you.
We'll give you our latest hot off-the-press t-shirt from the National Judicial College, because everyone deserves a good judge. Thank you again, and thank you all for coming, and hopefully we'll have you back here in the fall for our next Jackson lecture. Thank you all.